let's limit ourselves to the affidavit in support of your application. Limit ourselves to the affidavit. Let's limit ourselves to the affidavit.
In the affidavit, we have made quite clear that this truth is very crucial. We made it very clear.
But as to the God that he serves and all that, I think that we should not.
My Lord,
I don't think it is appropriate. Yeah.
That was in a declaration that we can all take judicial notice of. I mean, and my lords, I do not say that in a light vein. I do not say that in a light vein. I say that actually in a vein of solidarity with giving glory to the God that she serves. I say that in that vein, not lightly at all. And I say that that God is a God of truth. And it would honor that God if she would come forward to testify to the truth. And my lords, in the affidavit, in paragraph 21, furthermore, in the proceedings to date, counsel for first respondent has challenged the testimony on oath of my witnesses, including testimony provided by PW2, Dr. Pesa White, Dr. Michael Pesa White, that Mrs. Jean Mensa had in a meeting with PW3, Mr. Robert Joseph Metalunu, who also testified as PW3, sent the two witnesses who were serving as my agents at the National Collation Center, popularly referred to as the Strong Room, to go and deliver a message to me, with the promise that she would have a dispatch rider go and escort them back before she would make a declaration. Now, that's a matter on which that's a matter on which hearing her address the truth of that is important, because as the affidavit goes on to say in paragraphs 22 and 23, counsel could only challenge the witness's testimony.
I want the specific paragraphs you are.
Paragraph 21, and then now I'm moving to paragraphs 22 and 23.
I thought you stated earlier that the process should be divided into two, and that at this stage we are really dealing with whether the petitioner should be granted leave to reopen his case. I think it would be advisable if we stick to that one. If that is granted, then we could deal with the issue of subpoena and the truth and all of that. So I think it would help if we stick with the distinction that you yourself drew earlier. We should limit this to whether or not you should be granted leave to reopen your case.
My lords, I am grateful for that indication. Suffice it to say that I moved a little bit beyond that premise because of the issue of the discretion, the basis on which your lordship will exercise the discretion. And so we have, in all candor, to put before you what we are going to do if you grant us a leave. That's the only reason. And then when the issue of...
I think
that's sufficient. Very well, very well. My lords, we will be guided by... And I mean, I'm pleased to see that your lordships agree with the distinction that I made in the first instance. Because, my lord, indeed, my respectful submission is that at this stage, there is a sufficient basis from the circumstances that arose on, I believe, the 9th of February, when we closed our case. and when there was the expectation that the chairperson of the first respondent would actually come and testify on behalf of the first respondent. And my lords, I believe it goes without saying that on that day, your lordships, the Chief Justice himself, expressed some surprise at the turn of events, and for that reason asked us to come back the next day in order to address your lordships fully on the legal issues that arose. So, my lords, taking the cue, I now proceed to respond to the affidavits in opposition that were filed apparently yesterday, with some Valentine's Day messages to us. And my lords, in the affidavit of the first respondent in opposition to this motion, it is my respectful submission that there is unfortunate confusion as regards what the issues in this application are. That confusion includes claiming that we are here trying to review or appeal against the ruling of the 11th and so on. My lords, we are not here for that purpose. We've intimated that we are filing a review application as well, and we are within our rights to do that. But we are not here for that purpose, as suggested. And there are various claims which I do not wish to go into, because claims about vested rights which your lordship pronounced on and so on, which, frankly, are wrong. Your lordship did not, to my hearing, talk about vested rights, and I've gone over the ruling several times. But, my lord, the most startling passage in this affidavit in opposition is a passage in which the chairperson says something to do with disqualification. My lords, I wish to quote the exact words of that passage. My lords, this is paragraph 24. Paragraph 24. Again, I am advised that a subpoena is issued to a person, not to a party, to testify for the party on whose behalf it is issued. First respondent is a party and disqualified, and so am I. My lords, the rules about qualification to be a witness are provided for in section 58 of the Evidence Act, as well as section 59. Section 58 reads quite simply, except as otherwise provided by this decree, every person is competent to be a witness, and no person is disqualified from testifying to any matter. My lords, I shudder to think where she got her disqualification from testifying as a witness from. First respondent is a party and disqualified, and so am I. My lords, section 58 does not make that possible. Section 59 goes on, and that is a section about disqualification. So perhaps we can look for some guidance. A person, 59.1, a person is not qualified to be a witness if he is A, incapable of expressing himself so as to be understood, either directly or through interpretation by one who can understand him. I don't think we have any doubt that the chairperson is a person who is very capable of expressing herself so as to be understood. Then B, and I just read the beginning again. A person is not qualified to be a witness if he is B, incapable of understanding the duty of a witness to tell the truth. My lords, if any witness or anybody wishes to rely on that on behalf of the chairperson, they are welcome to do so and to claim to this court that she is incapable of understanding the duty of a witness to tell the truth. But these are the disqualifications mentioned in section 59. The final one, which is 59.2, a child or a person of unsound mind is competent to be a witness unless he is disqualified by subsection 1 of this section. So even a child is competent to be a witness unless disqualified under those provisions. So, my lords, I cannot imagine what this basis of disqualification that is so brazenly thrown in our face in paragraph 24 is about. And it goes on even more remarkably. A person subpoenaed is punishable by committal. What does that mean? I mean, a person who is subpoenaed is not punishable just by being subpoenaed unless they don't tell the truth. If they don't tell the truth, then of course they may face some consequences. And then finally, I'm advised that the decision of this court renders the proposed subpoena irrelevant. My lords, with the greatest respect, my lord, not only is it a question of law, the point I'm making is that those claims about committal and so on, they arise in the second stage that we are talking about, in the second stage, not at this stage. And therefore, your lordship should not countenance what is in the affidavit.
But Mr. Tsikata,
yes,
is it your proposal that we should rule on this quote-unquote first stage before you submit your you bring your submissions on the second stage?
No.
Is that your proposal?
No, my lady, that is far from my submission. My submission is quite simple. We are asking.
So you're presenting everything, are you not?
To the extent that I'm guided also by the...
Because you brought an application, and we must give one ruling on the application.
Absolutely. I don't expect more than one ruling. And all I'm saying respectfully is that I'm also guided by the cue from the bench that there's there's no need perhaps to go into all the issues related to the exercise of your discretion to the extent that they have to do, with what the testimony is going to be about. I mean, I take that point, that in terms of what the testimony is going to be about, it would not be appropriate for me to start going into all the details related to that, even though they are going to be important, and they are important parts of your exercise of discretion, but we have set them out in the affidavit sufficiently, and I decided I will not go into that into too much detail out of deference to the cue from your lordship. So, my lord, I'm not expecting two decisions. I'm fully expecting that there will be one decision, and I'm saying with the greatest respect that if that decision enables us to reopen our case, what we intend to do is to file a subpoena. That is all. That is basically, what brings together the two elements of what I'm submitting, that we will file a subpoena. And at that stage, whatever ground of disqualification she wants to bring forward, would be a separate matter. I cannot be arguing about the ground of disqualification at this stage. I just draw attention to the fact that in her affidavit in opposition, she seems to be talking about some ground of disqualification which is not consistent with the laws of evidence of this country.